challenged here has various procedural and substantive instances of unconstitutionality. And cited instances of infractions of fundamental rights. My Lord, we will only highlight about 5 quickly because we submitted on most of them. Number 1, starting with the housing levy captured in section 84 of the Act. It is our submission that this section purports to amend the Constitution. It purports to amend Schedule 4, Part 1, Part 2, Clause 8b, which exclusively gives the jurisdiction of housing to counties. The only leeway left for national government under Part 1, Clause 20 is housing policy. In purporting to create a levy and giving jurisdiction to the Cabinet Secretary to administer it, the Act is purporting to amend the Constitution, which cannot be allowed, and it's unconstitutional to that extent. The respondents seek to avoid that by saying that it's actually not a levy, it's a tax under Article 209(1). Lord, that does not answer the substantive issue of where the jurisdiction lies. By whatever name called, you cannot amend Schedule 4. In any event, my Lord, being taken to 209 can only serve the respondents adversely. For Article 209 is very clear on the kind of taxes that can be imposed. And it does not include such a tax as a housing levy or a housing tax. It is our further submission that it's unconstitutional to collect any form of tax, or in this case levy, without a foundational statute. You would have to establish, you have to get a statute to establish a housing fund, then you can collect such levies. That has not been done. I ask you, my Lord, to take judicial notice that in fact, having realized that anomaly, the respondents are only now trying to remedy that anomaly through a bill that is yet to be passed, the Statute Law Miscellaneous Amendment Bill 2022, which is yet to be considered by Parliament. And also you will note that at clause 83, they now seek to bring clauses that will bring definitions and a foundation for the levy. It is our further submission on that issue that so-called housing levy is discriminatory insofar as it only targets common employees and employers. That runs counter to Article 27. And to the extent that it is a mandatory contribution that amounts to servitude and offends Article 30. The last submission on that limb, my lord, is that they have sought to compound that illegality and unconstitutionality by requiring the Kenya Revenue Authority to be the collector of that levy. Under Section 5 of the KRA Act, Kenya Revenue Authority has no such authority unless introduced by legislation to collect this kind of tax. What they can collect is restricted. We invite my lord the ladies to take note that this particular limb of the petition has not been answered by any of the respondents on the unconstitutionality of bringing a county function to national government. Our second limb, my lord, your lady, is that the Finance Act, now challenged, introduces 22 new provisions out of 84. 22 new provisions that were not considered at the first reading, not considered at the second reading, and were not subjected to public participation. This constitutes 25% of the entire Act. Our simple submission on that respect, my lord, is that that scheme of things offends Article 201A of the Constitution that requires openness, accountability, and public participation. The respondents, especially the National Assembly, does not contradict that assertion. Their submission is that is a matter of the internal workings of the National Assembly, and the court should not interfere. We submit, my lord, with respect, that there is a good reason why the Constitution, the statutes, and the standing orders require that these processes be undertaken. And public participation is not internal to the National Assembly. My lord, my lady, limb number 3 is that, my lord, before I leave that, the totality of the new provisions are captured in paragraph 64F of the amended petition. They are all outlined. My lord, the third submission is on the scope of the Finance Act. Our submission, my lord, is that this Finance Act 2023 includes matters that are outside the ambit of a Finance Act. And also outside of the ambit of a money bill under Article 114(1) and 3. Article 114(1) and 3 as read with Article 209. My lord, we have outlined the Finance Act as captured, and the intention of any Finance Act, as with this, is an act of Parliament to amend the laws relating to various taxes and duties. Taxes and duties is always the ambit of a Finance Act. As we have demonstrated, my lord, this Finance Act has matters as if it's a statute miscellaneous amendment act. It covers a range of things from talking about benefits of a retiring deputy president and speaker, section 92 all the way to 98. It covers issues of at what stage should a statutory instrument expire in section 89 and 88. It covers such things as the constitution of the Kenya Roads Board in section 78 and many others. My lord, it is not open to the National Assembly to introduce everything and anything under the guise of the Finance Act, because the Finance Act has special protection for good reason. Such things can only be introduced in a Statute Miscellaneous Amendment Act, not the Finance Act. And to the extent that it has introduced all these strange things, it ceases to be properly a Finance Act as defined in law. More importantly, my lord, it then has a very serious result, and the result is it ceases to be a money bill under Article 114 of the Constitution. My lord, you will hear later why the Senate should have been involved. But the limit of this submission is once you introduce matters that are outside a money bill, then that bill ceases to be a money bill and ceases to have the protection in Article 114. In which case, it must get the concurrence of the Senate. My lord, that point has been prosecuted in the Court of Appeal successfully, and in our submission in E181, paragraph 29 of our submissions, we cite the case of the Speaker of the National Assembly and another versus Senate, where the Court of Appeal said that while a money bill is protected, there is one caveat, however, under Article 114(1) of the Constitution. A money bill may not deal with any other matter other than those specified in the definition provided at Article 114(3) of the Constitution. The implication being that the inclusion of other matters in a money bill would remove it from the purview of Article 114 of the Constitution, with the effect that it will no longer be enacted in accordance with the procedure of enactment reserved for money bills. The ambit of that, my lords, my lady, is that having then included all these other matters, then it became important and necessary that the bill goes through the process that any other bill would have gone through, including the Statute Law Miscellaneous Amendment Bill. It is therefore not open to the respondents to say this is a money bill and it's protected by Article 114. My lord, number 4, and of this I will not emphasize, I'll only mention, it is our submission that the Finance Act, insofar as it was passed by the National Assembly without the input of the Senate, therefore runs contrary to Article 110 on the question of concurrence on bills concerning counties. I will let the first petitioner and my brother Senator Mugeni submit at length on that. It is our further submission, number 5, my lords, that zeroing in on Section 33 of the Act, which seeks to charge VAT on insurance compensation, we submit, my lord, that this is an infraction of Article 40 in terms of protection of the right to property.
for compensation for loss in insurance is just that. It is restitution to where you are. You will not have purchased any goods or rendered any services. And in fact, there's no value addition that ought to be taxed. And seeking to tax this, therefore, is improper and offends the right to property under Article 40. It is our further submission, number 6, my lords, my lady, and it's captured in our submission, that in terms of procedure, there was a fundamental error that we did in the National Assembly, and that we failed to follow the provisions of the PFM Act and our own standing orders. Our submission, my lord, is that as expressly stated in those provisions, the finance bill ought to have been presented on the same day, at the same time, with the budget policy highlights. That is the gravamen of Section 43 of the PFM Act and Standing Order 244C, Clause 4. We ended up with a situation where we passed the bill, then came to discuss the budget later. It is our submission that there's good reason where they are to be presented together, so that the discussion on the budget can precede the act. And this was not done. Various explanations have sought to be given by the respondents for that, but they all belong to the realm of speculation. My lords, my lady, I have only given the outline because many of these will be submitted at length by various petitioners. But I want to say this. As petitioners, we look to you as the bastion, as the last bastion and bulwark against creeping disregard of the Constitution and the law. If my lord looks at the response by the second respondent in 219, my lords will see that we, as an institution of parliament, have become more executive than the executive itself. I am saddened to admit, my lord, that when it comes to observance of the Constitution and checking on the executive, the judiciary becomes the last bastion. It is of no consolation that we have independent offices and constitutional commissions. Because, my lord, as is evident, these two have been browbeaten to submission. My lord, we look to you and we look to this court to demonstrate that while it is entirely for any particular regime to determine its policy priorities, entirely for them, those priorities and the way of determination must be within the law. My lord, this petition is not about the choice of priorities. This petition is about whether the law has been followed. We have gone through what I would only call various epochs in judicialism. From 3.5 decades ago, my lords, when the Honorable Professor Wangari Maathai was described as a busybody in 1989, and the lawyers representing her, fairly eminent, were castigated. We have come full circle, my lord, to where these courts have had the courage to nullify presidential elections. Where these courts have had the courage to tell a sitting president in the BBI case that you are wrong. And I was on the other side of receiving that. But I'm happy that the court would have the courage to tell the chief executive and the executive generally when they are wrong. So should it be when it comes to the National Assembly, when it comes to the Senate and any other entity. My lords, my lady, as I close, we look forward to this court robustly examining the issues at hand without accepting the fear-mongering that you will hear from the respondents on the consequences of nullification of the act. Lord, we look forward to this new epoch where public-spirited individuals are complimented, not vilified. We submit, my lord, that once you retire to examine the totality of our submissions, we invite you to find the whole of the Finance Act 2023 as null and void. In the unlikely event, my lord, that you find it necessary not to avoid the whole of the act, we still invite you to nullify all those parts of the act that are clearly unconstitutional and an infringement of fundamental rights. My lord, I have exceeded my promised time by 2 minutes only. Thank you.
Mr. Mtata.
Is there a mobile mic? Oh, yeah. We can move for it.
Microphone.
Can you know what we can do? My lord, I think I can create space so that because I realize there's limited resources. Come.
Yes, thank you, my lords. My names are Senior Counsel Kongo Mogeni. I'll be arguing on behalf of the sixth petitioner. And my lords and my lady, the main argument that I'll be advancing before your lordships this morning is the effect that this law has been enacted by the National Assembly in contravention of mandatory provisions of the Constitution of the Republic of Kenya. My lady, in my opening remarks, the Constitution that was enacted by the people of Kenya in 2010 created a bicameral parliament that has two houses, the National Assembly and the Senate. My lords, in Article 94(1) of the Constitution, the legislative authority is donated to the two houses of Parliament. As we have stated in paragraph 48A of the petition, this bill in its entirety was never considered by the Senate. That's a fact, and it's not in dispute. The second argument, my lady, is that Kenya operates under a constitution that creates a limited government whereby there are powers that can be exercised by the government of the day, there are powers that are reserved for Parliament, and there are powers that are reserved for the judiciary. Now, to understand this very clearly, my lords and lady, Article 109 of the Constitution, which is very prescriptive, states how legislative powers should be exercised by the National Assembly and the Senate. And it's very clear, my lords, that there are laws that will only be enacted by the National Assembly. My lord, I want to read for the court the provisions of Article 109(3), which says that a bill not concerning county government is considered only in the National Assembly. So any bill that is not concerning county government, that legislative authority is conferred on the National Assembly. What then is a bill concerning county governments? My lady, that answer is provided for in Article 110 of the Constitution. And Article 110 states that in this Constitution, a bill concerning county government means a bill containing provisions affecting the functions and the powers of county governments. My lady, the bill, the impugned finance bill that is act that is before this House, it's not in dispute that it amended Section 31 of the Employment Act, and it created housing levy or housing tax that's supposed to be deducted by Kenyans and passed over to county government for purposes of constructing houses. The question is then, my lord, is housing a function of the national government, or is it a function of the county governments? My lady and my lords, that answer can be found in the last chapter of our Constitution, more specifically the Part 2 of the 6th schedule. You will notice that of the 4th schedule. You will notice that, my lords, the 4th schedule has designated functions that are reserved for the national government and functions that are reserved for the county governments. Now, if you go to Section 8 of Part 2, if you look at the heading of Section 8, it says county planning and development. So it lists the functions there. The first one is statistics, the second one is land survey and planning, the third one is boundaries and fencing, and the fourth one is housing. So housing as a function given to the county government includes county planning and development. So that, my lord, any law that has provisions touching on a function that the 4th schedule has reserved for county governments must be considered by the two houses. If it's a bill that has provisions that don't concern functions of county governments, under Article 109, that bill can be considered by the National Assembly alone. The question then begs, my Lord, if the National Assembly enacts a law in clear contravention of the provisions of this Constitution, what should be the effect of such a law? Our humble submissions, my lords, is that any law that is enacted without following a prescribed procedure in the Constitution is null and void and invalid. And I want to rely on the provisions of Article 2 on the supremacy of the Constitution of the Republic of Kenya. Article 2, my lords, is very clear that this Constitution is the supreme law of the land, but the provisions that are very key on the circumstances that are facing us is that no person may claim, that is Article 2, sub-Article 2, to exercise any state authority except as authorized under this Constitution. So this Constitution only authorizes Parliament as an entity to enact a law that has functions concerning county governments only if that law has been considered by the National Assembly and the Senate. As to what should be the fate of any law that has not complied with this Constitution, my lords, the answer is in Article 2, subsection 4 of our Constitution. And it says, my lords, that any law or any act that is enacted in contravention of this Constitution is invalid. My lords, this Constitution was enacted so that all institutions created under this Constitution must abide by it. And I want to give an example, my lords. What would happen if a judge sitting as a judge of the employment section was to exercise powers that are reserved by the High Court as created under Article 165? There will be chaos, my lord. Because Article 162 that creates system of courts has created limited powers to be exercised by judges of employment and environment court. And it says Parliament shall establish courts with status of the High Court to hear and determine disputes relating to employment and labor relations and then environment. Then 165 creates the High Court with unlimited original jurisdiction in criminal and civil matters. My lord, for there to be order, even within the institution of the judiciary, judges sitting in land, environment division must appreciate that their powers don't extend to the powers that are being exercised by the High Court created under Article 165. And we want to send the same message, my lords, to the National Assembly, that the powers that are donated to the National Assembly can only be exercised in accordance with this Constitution. Anything, my lord, done outside this Constitution is invalid, and it will create a very chaotic environment in our legislation. My lord, I want us to distinguish the Senate of the Republic of Kenya and, for example, the House of Lords. My lord, the Senate of the Republic of Kenya exercises its power on behalf of the sovereign power that has been donated to it by the people of Kenya. We are popularly elected by the people, just like the Senate of the United States of America, my lord. If you go to jurisdictions like Britain, the House of Lords does not enjoy popular mandate from the people. So that, my lord, the legislative authority of the Senate cannot be taken away whimsically by the National Assembly. That will be overthrowing the Constitution of the Republic of Kenya, more so the sovereignty of the people. Because Article 1, my lord, says all sovereign power belongs to the people. That is Article 1, subsection 1. And 2 says the people may exercise their sovereign power either directly or through their democratically elected representative. The Senate of the Republic of Kenya, my lord, is democratically elected by the people of Kenya. And there is reasonable expectation, my Lord, by all the people who reside in counties that the senators that they have elected democratically through a popular vote will exercise that legislative mandate as provided for in this constitution. My Lord, I want to bring it to the attention of the court that this...
Obviously, you were not here when I was allocating time.
Yes.
You know you're eating into the time of your other petitioners, and we're not going to extend that time.
Okay. So my Lord,
in
how many minutes maybe do I have? Or I'm already done?
You were done long time, because you know it is one petition.
Yes.
You're already eating into the time of the other petitioner. But if you wish to go on and inconvenience your colleagues, it's fine with us here.
Though then, in summary, my Lord, all the arguments in support of that violation of the Constitution is contained in the submission that were filed before this court, dated the 25th of August 2023. We have cited several cases from the Supreme Court that has clearly drawn a demarcation between the legislative mandate of the National Assembly and the Senate, and legislative process that should be exercised jointly by the institution of Parliament that constitutes National Assembly and the Senate. And all those decisions have been highlighted in our submissions that are before the court. We pray, my Lord, that specifically the provision that's amending Section 31 of the Employment Act should be declared invalid, null and void. And second, my Lord, the entire finance bill should be declared unconstitutional for containing provisions that are outside what is traditionally known as a finance bill. And finally, my Lord, the mutating of this particular taxation from a levy to a taxation renders the same invalid, and it should be declared unconstitutional. I thank you, my lords.
Senator Manzo, I hope you have talked to Mr. Ocheo that you are taking his time. Nevertheless, proceed.
Yes, my Lord, and I will attempt to shorten the time so that I don't take time of other councils, my Lord.
That is your decision. We have until 1:30.
My Lord, my issue is dealing with the public participation, and we wish also to adapt.
For the record, you appear for which party, just for the record?
My Lord, my name is Daniel Manzo. I do appear for the 7th petitioner. My Lord, yes. We wish to rely on the submissions of the 7th petitioner, which have been filed, and then go on to Article 10.2. Public participation is one of the values and principles of the governance that binds all state organs, state officers, and public officers, my Lord. The Finance Act 2023 did not meet the constitutionally set standard and the threshold of public participation as required under Article 118, whereby Parliament is required to facilitate public participation and involvement of the legislative and offer under the business of Parliament. My Lord, what happens in this particular case? Parliament makes an advertisement to the public, and the people reply by way of personally participating or through memorandums or through affidavits. That happened in this particular matter. There was a little bit of public participation which took place, but unfortunately, when the act was introduced and while it was on the floor, there were other amendments which were introduced, which were not subjected to public participation as it is a practice. The moment you go on third reading and other amendments are introduced in the House, ordinarily they are sent back again for public participation and the public is recalled. That did not happen in this particular case. We have highlighted that very well in our petition. And the question as to what amounts to adequate public participation was addressed in the case of Commission of the Implementation of the Constitution versus Parliament of Kenya and another 2013 EKL. 2013 EKLR, where it was held that what matters is that at the end of the day, a reasonable opportunity is afforded to members of the public and any entities, parties to know and parties to know about the issues and to have an adequate say. What amounts to a reasonable opportunity will depend in the circumstances of each case. So, my Lord, in this particular case, as I've just said, once new provisions were introduced, again as a practice of Parliament, that did not happen. And these particular new articles, which, my Lord, in our petition, the provisions that were introduced after clause of public participation exercise are in our paragraph 7 and 9 of the 7th petitioner. You'll find all of those provisions there. There are quite a number. And they are the ones which touch on some of the key issues, my Lord, in this particular petition. Then, my Lord, the petitioners contend that the National Assembly sneaked many provisions of the law into the approved bill on the floor of the House without subjecting them to public participation, hence violating Articles 10.2, 118, and 201 of the Constitution. My Lord, let me end by saying that when that fails to happen, and we have clearly demonstrated, and there is overwhelming evidence that happened, my Lord, unless those particular provisions are subjected to the people, and they are very key, and they affect the people of Kenya, who have the sovereign authority, then, my Lord, in regard of public participation, this bill fails in those particular provisions which were introduced and were not sent back to the public participation. And, my Lord, public participation, adequate public participation, following the advice of advisory opinion, which we have also cited there, Parliament was proposed to make a law on public participation. There was a bill of 2019, and unfortunately, when Parliament adjourned, it collapsed that, and it has not yet been introduced. So, my Lord, the country is yet to have a law on public participation, but there is sufficient guidelines in the Constitution as to, and by the court decision as to what public participation must be. My Lord, for those reasons, this act fails. The Finance Act 2023 fails for lack of proper public participation, and this court, even if it doesn't find the whole act wanting constitutionally, then these particular provisions, my Lord, should be taken back to the House. I thank you, my Lord.
Yes. This case of Commission and Implementation of the Constitution, and this story you just read what the judge said. I just wanted to clarify what, in your view, should be reasonable opportunity, or what do you understand by reasonable opportunity?
Reasonable opportunity, my Lord, from what we've been practicing in the House, is an advertisement through the newspapers, receiving of memoranda by the House, and then documents, and people be given an opportunity in a public place, which has been happening in all other acts of Parliament, and especially Finance Act in every year. There's usually a big meeting at KICC, which is well advertised. But what happened in this particular case, and we have put it in our submissions, the moment new provisions were introduced, I believe because of pressure of time, they were not subjected back to the people as it has always been the practice. So a reasonable opportunity was not accorded to the people of Kenya to make their contribution on the new additional provisions which were amended on the floor of the House. But unfortunately, the House did not go back to the people, and they went on to pass those particular provisions, and we have highlighted them in our submissions. Much obliged, my lords.
Thank you. Who is next in that matter? Senator? Yes.
My Lords and my lady, my name is Okio Mtato Koiti, the first petitioner in petition 181. I adopt my submissions of that 1st August 2023. At section B, paragraph 6, I've given a list of the documents I rely on, and an extra document that is not included is the petitioner's response, my response to the written submissions opposing the petition, and it is dated the 7th day of September 2023. My Lords, pursuant to Article 10, Policy Article 10, Article 165, 3D2, and Article 2, policy decisions are subject to judicial review. We have a prescriptive of the Constitution that even if it's a policy decision, it must be done according to the Constitution. I also submit that any bill touching on the Bill of Rights must be considered by both houses of Parliament, because even the county governments are subject to the Bill of Rights. Taxation affects property rights. It's also an administrative action under Article 47 and Article 40 respectively, and it must be subjected to consideration by both houses. In my submissions, I'll look at the other part of the petition. The petition was really in two parts. And I will highlight my submissions concerning the procedure for making the budget before we go to the finance bill. And it's my submission that Article 220, Clause 1, Paragraph A, defines what a budget is as a document that contains both revenue and expenditure. Now, when you come to this particular process we have had, and Article 221 gives the procedure for how those estimates have to be introduced in the National Assembly. Because it's a money bill, it has been introduced in the National Assembly pursuant to Article 109, Clause 5. And then those estimates also contain the estimates of Chapter 15 entities, which under Article 249, Clause 3, the Constitution expressly requires that Parliament, and when the Constitution uses the word Parliament, it means both houses. If it means one of the houses, it uses the name of the particular chamber. Under Article 249, Clause 3, it states that Parliament shall allocate adequate funds to the Chapter 15 entities. So it's my submission that since the estimates submitted under Article 221 contain estimates of expenditure of the Chapter 15 entities, it naturally follows that the procedure under Article 221 must be read with Article 249, Clause 3, and that would ensure that as per constitutional edict, the budget must be considered by both houses. In my submissions, I've also shown that after there were no estimates of revenue that agreed with Article 221, Clause 2B, that was submitted to the National Assembly. The document that are referring to as the estimates was not in the prescribed form under Section 38 of the Public Finance Management Act. So, I've submitted that the failure to involve the Senate in the consideration of the budget estimates and the Appropriation Act violated Article 249, Clause 3, and that voided the entire budget making process, not just the finance bill, the estimates, the Appropriation Act, and anything that was done under the budget process in the 2023-2024 budget cycle. in Parliament. It's also important to note that Article 96, 1 and 2 are very clear. And 91, the word is not to promote. The Senate is there to protect. So the question should be, why protect? And the only time the word protect is used in the Constitution is in that particular clause. Even in clause 3, it's not as much. It's also used there, but does not have the same connotation. To protect devolution. So we must look at the objects of devolution, including the equitable development of the country, and take into mind that the budget is executed in counties, and it falls upon the Senate under Article 201 and Article 174G to ensure that there's equitable development of this country, so that the national budget is not just done and then maybe all the resources are taken to one side of the country. That would defeat the objects of devolution. And that one requires the involvement of the Senate totally in the making of the budget. Because, my lords, as you know, that the government basically has one policy document. If it's not in the budget, it doesn't exist. So there's no way the Senate can be a bystander in the budget making process if the objects of devolution are taken into account. Also, I've also submitted that the failure to include, to enact the estimates of revenue, I'm assuming that they were introduced in Parliament. Yes, they have argued that they were introduced the estimates of revenue in Parliament, but then they disappear. Even the report, which is titled Report of the Committee on the Estimates of Revenue and whatever, do not have any word on the revenues. It only deals with the expenditure. So, my lords, the question that comes to mind is, where did the revenues of estimates go? And under Article 1, Article 9, 109 Clause 1, Parliament exercises its legislative authority through bills approved by Parliament and assented to by the President. We cannot introduce budget estimates through reports of Parliament. That's not how Parliament works. We do a lot of work in Parliament, reports, statements, motions, but Article 109 says the legislative authority of Parliament must start as a bill. And there is no bill that contains estimates of revenue that has been produced in this court. Further, my lords and my lady, I say that the failure then to enact those estimates of revenue into law means that this budget has got no revenue provision. And therefore, why do you need a finance bill? What will it be? A mechanism of raising which revenue? Raising revenue that has not been approved by Parliament? My lords, I also go, and still under 121, Clause 6. There's an interesting design in Clause 6, whereby the drafters say that the estimates of expenditure of the national government, of the Judiciary, and of Parliament shall be included in the Appropriations Act. It does not say they will form the Appropriations Act. What is to be included is to be added on to something else. And so the argument that the Appropriation Act only carries estimates of expenditure of the national government, of the Judiciary, and of Parliament is not acceptable under Article 6. They are included into something else. But if you look at the Appropriation Act of 2023, it only has estimates of expenditure. There are no estimates of revenue. Then you go back, and you are told under Article 220, Clause 1, Paragraph A, that the budget has two components. It has got revenue and it has expenditure. So if the Appropriations Act only has expenditure, where are the revenues in law? Why are there no revenues in law? And what happened to the revenue, the document titled Revenue Estimates of Revenues, although it was not in the format that the law prescribes, What happened to that document? Why was it hidden from the public? Why was it not subjected to public participation? And under Article 221, there's a clear requirement in clause 3 and clause 4 and 5 that the National Assembly will consider both of the estimates and both will be subjected to public participation. If you read the report of the committee, the estimates of revenue disappeared. And I will explain why later that has been done. So, my lord, the absence of the revenue estimate makes the budget incomplete. It does not conform to Article 220, Clause 1, Paragraph A. And an incomplete budget is no budget. So, as we speak, the national government failed and Parliament failed to enact a budget. There's no budget that's running this country. My lord, I also want to show that the Appropriations Act must be submitted to the Senate. And the reasons are found in the Constitution. If you look at Article 204, Clause 3, Paragraph A, it says that the national government may use the equalization fund only to the extent that the expenditure of those funds has been approved in an appropriation bill enacted by Parliament, not by the National Assembly. And when you look at Article 221, my lord, at Paragraph 2, at Clause 2A, it clearly states that these estimates of the equalization fund are part of the estimates submitted to Parliament. So, Article 221, have done that. Article 223, Clauses 2, 3, and 5 also underscore the fact that the Appropriation Act bill must be enacted by both the Senate and the National Assembly. And in fact, Article 223 is so good because it refers in some paragraphs to Parliament, in some paragraphs to the National Assembly, clearly distinguishing what the National Assembly can do and what is expected of the entire House to do. And so I'm saying that because the Appropriation Act was not submitted to the Senate, that act is null and void, other than being also void for not containing estimates of revenue, which should be to which the expenditure should be included. My lords, we have also highlighted the fact that there are very clear cases of budgeted corruption in the estimates of the current expenditure that has been given, and those are highlighted out, and those recurrent the budgeted corruption, including that involving domestic debts, goes to more than 1 trillion shillings, which, if removed, we don't have to have this punitive taxation that the Kenyans are being subjected to. We have highlighted those things in our submissions. Finally, I will submit that the finance bill, as presented to the National Assembly, as published by the National Assembly, was a bill concerning county governments that ought to have been taken to the Senate, but was not, and that voids the finance bill ab initio in its entirety. Also, the fact that it is anchored onto provisions, onto the budget estimates and the Appropriation Act, which themselves violated the Constitution, then it's also void ab initio. So, my lords, with those few remarks, I plead with the court. Just very close, I also want to point out what was not mentioned about the housing levy. The housing levy has been applied in a blanket manner without exempting judges and officials of the Chapter 15 entities from the levy. Yet the Constitution says their salaries cannot be interfered with. during their stay in office. So that particular issue should also be taken on alongside with other provisions that have been built. So it's my submission that in its entirety, the budget making process was flawed. And as we say, a river does not flow higher than its source. The Finance Act cannot survive the infringements that preceded its introduction into Parliament and that accompanied it in the process of being enacted. So we pray that you void the Finance Act, you void the Finance Act, you void the Appropriation Act, the current Appropriation Act, the current Finance Act, and also you void the estimates in their entirety for violating the Constitution. With those, thank you very much, Your Lordship. But we had prepared, my Lord, last time. You know, you had given a directive that each petition had been given 10 minutes. And though we are appearing on the same petition, it's just that we had a meeting on mind, so people had different issues. You have submitted on a slightly different issue. So everybody submitted submissions in his area where he contributed to the petition. It was not a petition by Umtata and I invited others. It was a petition whereby people who meet away from alcohol but over tea caucused and agreed that they would do. So as you will notice, everybody submitted on the area where I contributed. So I'll really be pleading with you that you allow the remaining...
oh, they will be allowed, but until 1:30. That's fine.
Most obliged, my Lord.
Yes. Eliud Karanja Matindi. Eliud. Yes. Okay. Yes, now you're eating into Mr. Dudley's time.
I'll be very brief. Thank you very much. I'm having a PowerPoint presentation, and just a bit of it. Please, if you can have it on, from slide 14. Yes. Okay. So, what I'm showing is...
introduce yourself, please.
Thank you very much. I'm Benson Otieno, the fourth petitioner appearing in person. Yes, I'm Benson Otieno, fourth petitioner appearing in person. I want to address you on unconstitutional expenditure estimates, and I am personally aggrieved at a figure which is 1.2 trillion, which is a quarter of the budget, Kenya's budget 2023-2024. It is an unconstitutional expenditure in the sense that it involves borrowing, which was not approved by Parliament. And that is what I'll be presenting on. So, my lords and my ladies, the role of legislation in borrowing is entrenched in the Constitution from Article 211, which says that borrowing must be anchored in law. If you look at Article 214, says that public debt is a charge of the consolidated funds. Now, a consolidated fund is a contribution of taxes. So anytime you're going to withdraw money from that fund, then you're talking about borrowing, and there must be legislation on it. This is entrenched under Section 15(2) and Section 53 of the Public Finance Management Act. It has been submitted by the respondents that Parliament approved borrowings of 717 billion. Good sir, if you could go to, can't even see it, I think I'll abandon it for now. If you go to that, we have 717 billion and some points there, that is what was approved. The evidence that has been put on record shows that only 313 billion was approved by Parliament. My lords, my ladies, there are only two possibilities when you're having finances being borrowed, when there is no law which has approved them. And you know, you can only borrow to finance development expenditure. You cannot borrow to finance recurrent expenditure. And that is the role of the Parliament to oversight that. Now, there are only two possibilities. The first one is obvious. The second one is a prayer that people can maybe just pray. So it is only possible that it will be stolen, or that the money that was not approved to be borrowed can be used to finance recurrent expenditure, which is illegal if you look at Section 53 of the Public Finance Management Act. Thank you. My Lord, my ladies, I'm looking at the Cabinet Secretary's response to issues that we have raised concerning budgeted corruption. And our starting point is that Section 33, Clause 3 of the Public Finance Management Act states in very express terms that when you're drawing a budget, it must be accurate, precise, informative, and it must also clearly identify the appropriations by vote and programs. So every appropriation must have a vote and must have a program. Our allegation, which we have shown through our affidavits, and I direct you to the supplementary affidavit by the first petitioner, dated 24th of August 2023. You look at that, and we are showing that there is 21.65 billion, that the response we have been given is that that money was used or will be used to finance wages for temporary employees. We have 5 responses to this. First, government does not have temporary employees. Government can only have employees under contract or permanent and pensionable employees. If you look at Section 68G and H of the Public Finance Management Act, it provides that every government entity is having a duty to present and produce strategic plan for that entity, as well as the revenue estimates for that entity. The only caveat that has been given is that those entities must do so in conformity with the medium-term fiscal expenditure. That is absent, and we are having an omnibus, or what we call a universal strategic plan, according to the response by the third and fourth respondents. So, my lords, my ladies, our presentation is that Regulation 40 Clause 3 of the Public Finance Management Regulations states that the only time you can have a supplementary budget is when it was unforeseen and unavoidable. But here we are having a supplementary budget for things which are being seen. Somebody is able to forecast. So how do you forecast and call it a supplementary budget? So that one we have faulted that, and we ask you to look at paragraphs 29 through 34 of our supplementary affidavit dated 24th of August 2023. My lords, my ladies, there's a paragraph there in red. We have flagged at least 3 areas which are outright and clear that there has been budgeted corruption, and these are: we are having a budget for Kenya Railways, the SGR from Nairobi, Mombasa, then the Naivasha SGR. Despite their completion in 2019 and 2017, we are still having a budget. Then we have been told that those budgets have been done by the National Treasury. And our presentation is, our argument is, the National Treasury cannot do that because it is not an entity mandated to do that. If we were to have those budgets done at entity level, then it will be Ministry of Transport that is to do that, not the National Treasury. So the National Treasury cannot do estimates of revenue and all those budgets for entities because each entity constitutes a separate vote. And the meaning of separate vote is entrenched, Section 33, Sections 37, 1 and 2, as read with 39, 1 and 2 of the Public Finance Management Act. My lords, my ladies, I will conclude by saying that we have also shown that thank you very much. Now, we have also shown that there is a possibility that we have 2 different budgets, one that was presented in Parliament and the one that has been published. And that one has been shown. Look at our supplementary affidavits, as well as the second amended petition, paragraphs 34, paragraphs 14, and 29. My lords, my ladies, I wanted to show though time will not allow me now, that you've looked at the procedure, look at the procedure that must be followed, and you find that it is a very simple procedure that has been brought out in very simple terms, but somebody must be very awkward and strategic in order to avoid it. We have shown why there is that appetite for somebody to avoid that, and you will find that in our pleadings. My lords, my ladies, as I conclude, my time is up. I would say that we are having a constitution of Kenya 2010, and one of the things that not many writers have said about it is that it is written in simple, plain English, that anybody who is able to comprehend English as a language can read and comprehend. Now, their constitution also talks about, I also say that the constitution is written in active voice, and it begins with the word we. So anytime you're interpreting this constitution, my lord, you are talking, these are Kenyans talking, it's only that they could not be here, all of them. So it is written in active voice, and whenever they said something, they meant it. Thank you very much.
Thank you. My lord, yes. I wish to go and present next. My name is Uzalendo, my girl. Good morning.
Yes.
My name is Uzalendo, my girl. I am the fifth petitioner in petition E181 of 2023. I do wish to appear before this court, and I do not want to take more than 10 minutes because the issues that I was to canvass have already been spoken about by Senior Counsel Ochiende Amolo and Senior Counsel Okongo Omogeni. However, I wish to go forward and compound on the issue of concurrence. My lord, I wish to state as follows. Article 93 of the Constitution establishes the formation of Parliament, and it states that Parliament shall consist of both the Senate and the National Assembly. My lords, in clause 2 of Article 93, both the Senate and the National Assembly have the mandate and obligation to exercise their authority in accordance with the Constitution. My lord, I take us to Article 94.5, which states that Parliament is the only organ with the mandate to formulate laws. My lords, I present that Parliament never enacted the Finance Act. Why am I saying this? Because as you read Article 93, it categorically states that Parliament constitutes of the National Assembly and the Senate. My lords, when you read Section 96, Article 96.1 of the Constitution, it envisages a provision that Senate will protect the interest of the counties and their government pursuant to Article 96.1. Further, my lord, my lords and my lady, I wish to take us to Article 110.1, which states that Article 110.3, which states that before a bill is introduced in either house, then there has to be concurrence between both speakers of the National Assembly and the Speaker of the Senate. This was elucidated in the case, or rather in the advisory opinion number 2 of 2013, whereby the Supreme Court stated that concurrence is a mandatory. It's a preliminary mandatory obligation that Parliament or both houses must concur before a bill is introduced and before the first reading. My lords, I also wish to reaffirm that position, as was in the case of Senate of the Republic of Kenya and 4 others, versus the Speaker of the National Assembly and another. My lords, my lady, in this case, Senate was aggrieved that the National Assembly had passed 23 laws which lacked concurrence and therefore moved to the High Court. Among those 23 acts that were passed without concurrence was the Finance Act number 10 of 2018. My lords, when delivering their judgment, the the court stated that one Speaker of the House of Parliament cannot unilaterally decide as to whether a bill does or does not concern counties, and therefore should seek guidance pursuant to Article 110(3) of the Constitution of Kenya. My Lords, the respondents in that matter appealed, and the case was presented before the Court of Appeal as stated, Speaker of the National Assembly and another, versus Senate and 12 others, which is a 2021 case, which the Court of Appeal upheld the decision of the High Court. My Lord, I present to us, we have locus classicus emanating from the Supreme Court, the Court of Appeal, and the High Court, and all these precedents, both persuasive and binding, should guide this court when you are retiring to write the judgment. My Lord, I wish to cite finally the case of McFoy versus United Africa Company Limited, in which it stated that if an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is thus no need for a court to set aside, because it's automatically null and void. However, for convenience purposes, the court may do so. Every proceeding founded on bad law is incurably bad. You cannot put something on nothing and expect it to stay there. It will eventually collapse. My Lords, I present to us that the Finance Act did not adhere to the provisions of the Constitution, and I pray for this court to render a decision that the Finance Act is null and void ab initio for the want of concurrence. Thank you. I humbly submit.
If it may please, my Lord. We've consulted, and with the concurrence of my colleagues, in 181, we have agreed, and Mr. Mutindi will confirm, that petition number 2, 8, 9, and 10 will adopt the submissions that we have already given in this matter to save time for the other petitioners. With one rider and request, my Lord, that once the other petitioners are done, we will, you could then allow Senator Okiya Omtatah only 10 minutes to prosecute the contempt application, as we had said, so that it's all considered together. That's our request, Your Lady. My Lord, thank you. So, I don't know if it goes fast.
So the other petitioners are adopted in 181?
Yes.
Are adopted,
yes.
So we go to 211.
Your Lordship, in the matter, my name is Chirongis, appearing together with my learned colleague, Nyaboke Makori. Your Lordship and Lordship, in petition 217, we've raised 5 fundamental questions that this honorable bench should consider and render the Finance Act 2023 invalid. Your Lordship and Lordship, I'll proceed to one of the questions that has been posed for deliberations and consideration. Is whether Section 52 and 63 of the Finance Act threatens the consumer economic rights of small business enshrined under Article 46(1)(c) of the Constitution. my lords and my lady, Section 52 and 53 introduces electronic tax system and makes it mandatory for all the businesses to issue receipt electronically. At the same time, to keep their tax records electronically. Your Lordship, we humbly submit that this violates the rights of small businesses, for the reason being that it's expensive, it's not convenient for the small businesses, for the reason being that they will be required to obtain electronic devices, be it computers or laptops, for the daily transactions of their businesses. And they will also, the law requires, the mandates these small businesses to keep the records in electronic form for a period of 5 years. My lords and my ladies, these small businesses are prejudiced on the basis that they are not making enough profit that enable them to run their businesses, and therefore acquiring these electronic devices will make it expensive, and therefore violates Article 46(1)(c) that guarantee the economic rights of our Kenyan people. To the second question that have been posed for deliberations is whether Section 38 of the Finance Act threatens food security under Article 43, Sub-Article 1(c) of the Constitution. Your Lordship and Lordship, Section 38 of the Finance Act amend value-added tax, that is number 35 of 2013, and exclude the staple food in this country from the list of zero rating items, that being the maize flour, cassava flour, and the wheat flour. Your Lordship and Lordship, history will prove us right that maize is a staple food in this country, that by deletions and exclusion of the same item in the zero rating will prejudice our citizens of this country, because they will not be in a position to access and enjoy the staple food in this country. So the amendments introduced by Section 38 violates the food security entitled under Article 43(1)(c) of the Constitution. Another question that has been posed to this honorable bench to consider and render the Finance Act 2023 unconstitutional is Section 38 of the Finance Act. The same finance section within the Act introduces other items, around 11 of them, to be zero rated, but at the same time excluding the staple food. This poses two threats. One is it's allow some of the items an equally enjoyment of the law, at the same time excluding the staple food of which this country, the people of this country should be entitled to enjoy. And by the exclusion and inclusion of other items, violate tax principles provided under Article 201, that equality enjoyment of the law has to be equal, as provided under Article 27 of our Constitution. The fourth question that has been posed to this Honorable Court is the issue of housing levy. The reason why we objecting the introduction of the housing levy under Section 84 of the Finance Act is that the amendment doesn't present the views of the people of Kenya. These are only views of the elected leaders who enjoy delegated powers, indirect powers that they exercised. The housing levy is not practical in the sense that if we do adopt an estimate figure of a purchase of a unit of a house, let's put 1 million per unit that has to be purchased. If we calculate 1 or 2% of the deductions of the salary, that means that in the course of the year, the collected amount is 24,000. If you multiply that amount, and if you do calculation, it might take almost 100 years for the Kenyans to benefit from the housing levy. Therefore, the introduction of the housing levy is not practicable in these circumstances. The reason why we still raise a constitutional issue in regard to the housing levy is Article 40 of our Constitution, that protects the rights of property rights. Your Lordship, if by the scheme and the mandates of the government elected at the end of the day is to ensure that this housing levy is collected and the government to identify specific place where these properties can be raised, constructed, and be delivered to Kenyans, we submit that violates the rights of Kenyans, specifically at Article 40, for the reason being that there are some Kenyans who've already acquired their houses. They enjoy a place where they should live, as provided under the Constitution, and therefore, if the government will be mandated to choose to identify and construct houses in specific places, that is not a pure enjoyment of their property to rights. On the last issue, on the issue of public participation, sovereignty, and the values, Your Lordship and Lordship, I do submit that the first respondent, the National Assembly, as provided under Article 1 of the Constitution, Article 1, Sub-Article 2, that people may exercise their sovereign power either directly or through their democratic elected representative. We do submit that Parliament, that encompasses the National Assembly and the Senate, they are mandated to legislate laws that represent the views of the people. And the best where Kenyans can exercise the indirect supervision of the powers for the elected leaders is through public participation. Your Lordship and Lordship, we do submit that yes, there was public hearing. As you retire, you look at our submissions. The essence of the public participation is not only to call the citizen to participate in the process, but their views must count at the end of the process. In this Finance Act, we do submit that that was not considered, Your Lordship. It's not a matter of beauty contest, it's a matter that the citizen of this country must submit and their views be considered. Your Lordship and Lordship, as I finalize, we request this honorable bench, pursuant to Article 23, Article 165, 258, 259 of the Constitution, to declare the Finance Act unconstitutional and allow the petition as read. Much obliged.
name is Nyakirila. I am in 211 Budgetary here. I know that I can be allowed here.
You wait we have last one. Wait for your chance.
What's your question?
I called it. E219 of 2022. Post. Okay.
My name is Ometo.
Yes.
My name is Ometo.
Yes.
Honorable Tiende Amolo
Pardon?
Honorable Tiende Amolo has already addressed it.
Okay. E221 of 2023, Petitioner Law Society of Kenya.
Wait, please, the court. The matter, my name is Theuri. I will address the court for about 5 minutes and then donate another 5 minutes to my colleague, Mr. Ngoloma. Lord, the petition by the Law Society has challenged Section 7 and Section 84 of the Finance Act. I adopt the submissions that have been made with regards to the housing fund. My Lord, I just want to add that in terms of the constitutional test of purpose and effect, as set out in Article 201 of the Constitution, we submit that that amendment fails to meet the constitutional threshold. The fact that, my Lord, Section 84 amends the Employment Act, and the preamble to the Employment Act defines it as an act that seeks to define the basic conditions of employment and related purposes. My Lord, we also have in our laws the Housing Act, which at Section 6 establishes the Housing Fund, supposed to be controlled by the National Housing Corporation. And my Lord, to that effect, we submit that and join the submissions that have been made, the lack of a framework law to anchor those changes that were introduced and the amendments done to the Employment Act therefore violate the constitutional test of purpose and effect and brings to fore uncertainty within the law. Because, my Lord and my Lady, it is not even clear who is eligible to benefit from this scheme in the absence of a framework law. And that goes to also the impropriety of the public notice appointing the Kenya Revenue Authority as the body to administer the housing levy. My Lord, there is also the question of whether the act can be enacted in such a way in light of the provisions of the Constitution, and particularly Schedule 4, that gives the county the function of housing in Schedule 4 and the function of creation of policy to the national government. And my Lord, it is our submission that to adopt any other interpretation would be to give the development of policy a different meaning, and to that extent we also join in the submissions that were made by Mr. Tiende Amolo that that section would, in effect, be seeking to amend the Constitution. My Lord, for those reasons, we join the rest of the petitioners in imploring this court to find that Section 84 of the Finance Act violates the Constitution for the reasons that we have stated and the reasons that we have stated in our submissions, and to proceed to declare that section as unconstitutional, void, and of no effect, and my Lord, to consequently order that any funds that have been collected would be refunded. My Lord, I cede the floor to my colleague, Mr. Goloma.
Good morning, my lords, my lady. As my president has indicated, my name is Ngoloma. I will be submitting briefly on the issue of whether meaningful public participation was conducted in as far as the third reading introductions, the provisions that were snuck in at the third reading. My lord, for clarity, these are sections 24C, paragraph 72 and 73, section 44, 47, 5, 100 and 101 of the Impugned Finance Act. Yes. Section 24C, paragraph 72 and 73. Section 44, 47, subsection 5, section 100 and section 101 of the Impugned Finance Act. My lords, my lady, there have been extensive submissions with respect to this issue of public participation. Mine is only to address the rejoinder that has been put forward by the respondents. My lord and my lady, the respondents hide behind the standing orders 133 to allege that it allows them to introduce amendments at any stage of the legislative process. My lords, my lady, they further state that the introductions were in fact products of public participation. And on the basis of these two arguments, they claim the same to be constitutional. My lady, that proposition is both factually and legally unfounded and mistaken. First, my lady, on the basis of fact, it is the respondent submission that there was proposals by Sanabil, Kenya Wines Agencies Limited, and Tatu City Limited, as well as KPMG, that resulted in the introductions of these new provisions. In fact, from the report of the committee, it is only Kenya Wines Agencies Limited whose proposal was received and amendments to that effect accepted. My lords, my lady, even just this argument in itself reveals a problematic issue of partiality. My lord, some proposals by the stakeholders were rejected by the Finance Committee for want of public participation, that they were being introduced at that stage. My lord, I refer you to page 86 of the report of the Departmental Committee on the Finance and National Planning, where they rejected KPMG's proposal on the basis of the stage at which it was being introduced. Yet, the other provisions that were introduced at the very same stage, they seem to now hide behind and say that they came from the public. My lord, secondly, to demonstrate that they are legally unfounded, that position is legally unfounded, to propose that the Standing Order 133 overrides constitutional and statutory dictates is a shock to the petitioners. My lords, my lady, in fact, the drafters of the very same standing orders were of the same view that these standing orders must be read in line with the Constitution and statutory provisions. Hence why Standing Order 133.6 clearly provides as what are allowable amendments at the committee stage. My lord, it clearly provides and I will refer this court to the authority in Kenya Bankers Association versus the AG and another. Where the court was very clear that no amendment shall be moved which is inconsistent with any part of the bill already agreed to or any decision already made by the committee. My lord, in fact, the standing orders further say that the additions must be minor amendments and not substantial additions. This is a position that the apex court of this land, my lord, in the BBI case, the AG and 2 others versus Ndi and 79 others. I'll refer this court to paragraph 270, 302, and 1938 of the Supreme Court's decision. And most notably for this court's understanding, this court simply indicated that there is no evidence of any form of public participation or deliberations between 21st October 2020 and 25th November, when changes to the BBI steering committee draft bill, including the second schedule, was added that show public engagement and consideration of the issue of apportioning and allocating the subject counties, additional constituencies. My lords, my lady, we humbly submit that it is an issue that has been clearly and unequivocally determined by courts, both at the Supreme Court level and at the Court of Appeal record. What is the ambit of the amendments that can be introduced at the committee stage? It cannot be that substantive additions are made in the guise of minor amendments. And to allow such an infraction would be going against the principle of public participation, where Parliament can introduce completely any alien provisions in the guise of introduction from public participation. My lord, last year I will only address the issue of the retrospective application of the law for the period that it had been suspended, and only to respond to the rejoinder given by the respondents. And my lord, very notably, they all hide behind the fact that according to the impugned section 31C that was introduced, the collection period of this housing levy is 9 days after the preceding month. So for them, the argument is that the collection period was after July, so the first 9 days of August. My lord, we are not here to argue on the collection period of the levy. We are here to submit on the date of the effective date and when the housing levy came into force. My lord, for that period there was a conservatory order that had suspended the implementation from 1st of July up until the date that the court lifted the conservatory order. For that reason, it is our submission that any implementation of that provision of the law, of the impugned act, during a period when there was a subsisting conservatory order suspending its implementation, amounts to retrospective application. My lords, my lady, that will be all on my part.
There is one last E227 of 2023.
My lords and my lady, with your kind permission, my name is Ochieng Oginga. I do appear together with my colleague, Ms. Wangui Njoroge, who is present. On behalf of the petitioners, I will be relying on the amended petition dated 31st August 2023, together with the affidavit sworn in support of the same by Raila Amolo Odinga, written submissions dated 31st August 2023, and a list and bundle of authorities equally dated 31st August 2023. I wish to center my submissions on two broad areas, namely taxation and devolution, in light of the Finance Act 2023. Now, the first issue I wish to address is whether Sections 2 and 84 of the Finance Act are unconstitutional. And to that extent, I submit that the two provisions are unconstitutional and in contravention of Articles 10, 110, 209, 186(2), and 210 of the Constitution. My Lord, pursuant to Article 110 of the Constitution, a bill concerning county governments means a bill containing provisions affecting the functions and powers of county governments. Now, for that proposition, my lords and my lady, I refer the court to be guided by the decision in the matter of the Interim Independent Electoral Commission, that is Constitutional Application number 2 of 2011. That is contained at page 12 of my bundle, and more specifically paragraph 40, where the Supreme Court pointed out and stated, we consider that the expression any matters touching on county government should be so interpreted as to incorporate any national level process bearing a significant impact on the conduct of county government, my lords. Now, in this case, my lords and my lady, Section 2 and 84 contain provisions touching on entertainment tax and the housing levy. My lord, I submit, pursuant to paragraphs 8, part 2 of the 4th schedule, county planning and development, including housing, is a key function of county governments. And the role of the national government is only limited to initiating a housing policy. It cannot go beyond that. My lord, now for that proposition, I invite the court once again to consider the decision in the Law Society of Kenya versus Cabinet Secretary, Ministry for Lands. That is at paragraph 11 of my submissions. Now, more specifically at page 35 of my bundle, at paragraph 54 in that decision. Now, the court emphasized and stated the words housing policy and housing are used in the 4th schedule in respect of national and county government functions. Now, the mandate of the national government involves the accreditation, regulation, and promotion of quality assurance and technical capacity assistance in the construction industry at large, while the county government is involved in housing to the extent of planning and development within the counties. So that, my lord, housing matters are an exclusive preserve of the county governments. My lord, in further interpreting paragraph 8, part 2 of the 4th schedule, I invite the court to apply the principle in Tinyefunza versus Republic, whereby the Constitution is to be interpreted as an integrated whole, with each provision complementing and supplementing each other. Now, my lords and my lady, you'll be told that housing function is a socio-economic right under Article 43 of the Constitution, and hence it is a preserve of the national government. Now, I submit, my lord, whereas housing is one of the socio-economic rights under Article 43 of the Constitution, the Constitution is expressed when it lays emphasis on these socio-economic rights that are to be co-shared between the two levels of government. My lord, in fact, if you look at Article 204.2, for example, it specifically introduces the Equalization Fund. And it states, my lords and my lady, permit me to read, the national government shall use the Equalization Fund only to provide basic services, including water, roads, health facilities, and electricity to marginalized areas, to the extent necessary to bring the quality of those services in those areas to the level generally enjoyed by the rest of the nation so far as possible. So that in this provision, my lord, the services referred to are also contained under Article 43 of the Constitution. But in this case, the Constitution has gone further to specifically delimit these particular functions to denote that they can be co-shared between the national government and the county government. Now, my lords and my lady, secondly, Section 2 of the Finance Act introduces income tax on income generated from digital platforms. My lords and my lady, I submit that Article 209 restricts the nature of taxes to be imposed by the national government and restricts it in form of imposing entertainment tax, so that the digital platforms income encroaches on entertainment tax under Article 209 of the Constitution, so that again the Act itself encroaches on the mandate of the county government. My lord, again, under Section 2, the digital content monetization as defined under the Act is ambiguous and uncertain, my lord, and the same is contrary to Articles 186.2 as read with Article 209.3 of the Constitution. Now, I refer the court to the decision in Real Deals Limited and 3 others. That is authority number 3 in my bundle of authorities, and more specifically, page 56 of my bundle, and that is paragraph 72. And I urge the court to uphold the holding that, in my view, this is the court speaking, the respondents cannot be allowed to usurp the mandate and powers reserved to another state organ under the guise of collection of revenue for the country. My lords and my ladies, again, you will be told that the speakers made a decision and determined that the bill does not involve the counties. I submit that the determination of whether a bill concerns county government is not an exclusive preserve of the speakers of the two houses. This court has the ultimate powers pursuant to Article 165 of the Constitution to determine and make a pronouncement on that question. So that in this case, that decision is being treated as if it is a private affair between the two speakers. But we submit that is a decision, an administrative decision, that is subject to review by this honorable court. And hence, this court reserves the exclusive jurisdiction to determine the validity of a decision by the speakers made under Article 110, Subclause 3 of the Constitution. My Lord, now on taxation, on the second limb of my submission, first I begin by saying that it is trite law that legislation needs to contain certainty and clarity. So that this principle, my lords and my lady, has been described as a fundamental tool in the legislative process. Now, permit me, my lords, to refer the court to the article by one author, Alexander Deming. It is titled Certainty and Uncertainty in Tax Law. That is a Siberian Federal University Journal publication. Now, my lord, I refer specifically to page 133 of my bundle, where the author identifies 4 key elements underpinning clarity in taxation law. Permit me, my lords, to read. First, the author points out that certainty in law is the cornerstone of the state governed by the rule of law. The lack of certainty in law deprives it of its ability to perform its functions effectively, to form a stable legal order, and to direct, in bracket, guide people's behavior in particular. And then, finally, the principle of certainty of taxation is the ideological basis of all modern taxing systems. Now, secondly, my lord, permit me to refer also to the 7th article on my list of authorities. That is Daniel Dick. The article is titled Neutrality and Legal Certainty in Tax Law and the Effective Protection of Taxpayers' Rights. This is an Acta Juridica Hungarica, Budapest journal publication. So that for that article, I refer the court to page 163 of my bundle, where the author points and says, taxpayer rights can be exercised effectively in a well-established system of tax law. It is important to look for the quality of tax legislation, in other words, to know about the conditions in which the tax law can be considered as ideal. It should apparently rest on a sound normative basis. My lord, the other authorities I also wish to rely on and articles, but the upshot of the submission, my lord, is that tax legislation has to be certain. So that in applying these principles, my lord, if you look at, for example, the housing levy, first, what is apparent from the responses tendered so far is the definitional challenge. We don't know, the taxpayer does not know whether it is a levy or a tax. What is it? That is the first definitional challenge, which ought not to be the case for any taxing legislation. Secondly, the imposition and enactment of that provision ought to have involved both houses of parliament. Again, the housing levy is uncertain on the mechanisms that will be used to achieve affordable housing. It fails, for example, to disclose how the funds will be computed, raised, disbursed, and utilized, my lord. Again, on the final issue, on the legality and constitutionality of the Act, I quickly point out to Section 33 of the Act, which introduces VAT on compensation. So that in that context, my lord, Section 33 is contrary to Article 24 of the Constitution, as it introduces a limitation on the right to property under Article 40. And it does not pass the threshold for limitation of rights. Finally, as I conclude, my lords and my lady, I urge the court to allow the petition, and I invite the court to reiterate the findings by the Supreme Court in the matter of the Speaker of the Senate, that is authority number 10 in my bundle of authorities, where the Supreme Court was emphatic and stated as follows: it emerges that Kenya's legislative bodies bear an obligation to discharge their mandate in accordance with the terms of the Constitution, and they cannot plead any internal rule or indeed any statutory scheme as a reprieve from the obligation. Then secondly, the Constitution vests the legislative authority of the Republic in Parliament. Such authority is derived from the people. And finally, my Lord, pursuant to Article 93(2) provides that the National Assembly and the Senate shall perform their respective functions in accordance with the Constitution. So that as I close my submissions, my Lords and my Lady, any legislative process that falls short of the constitutional muster can be best described as legislative deception. That's all, my Lord.
Thank you very much.
Thank you, my Lord. My Lord, I'll make 5 highlights. My Lord, I make 5 highlights, relying for the rest of the argument on my written submissions. I'll highlight the issue of regressive taxes, the statutory instruments question. I'll take you through the public participation issue, my Lord. And lastly, the climate change violations. My Lord, and then I'll conclude with the issue of money bills and money bills concerning counties. My Lord, beginning with the issue of regressive taxes, Article 10, 21(3), 201 demand that taxation must be fair. In the Charles Macharia case delivered last week by the Supreme Court, the court restated the Article 21(3) obligation of all state organs to redress the needs of the vulnerable. In that case, children in juvenile justice, in this case, the poor in taxation. My Lord, the World Bank, in its June 2023 economic update for Kenya, indicates that Kenya has been beset by an economic polycrisis because of the worst drought in 40 years, because of the lingering effects of COVID-19, and because of the ongoing global economic meltdown. The National Treasury acknowledges that. If you look at page 94 of the 2023 BPS, the National Treasury tells us that it reduces disposable income. And the other thing that BPS tells you, my Lord, is that the poor spend more than 60% of their income on food. Ordinary households spend about 54%. It is in the BPS. And so, when in an economic polycrisis, where government is saying that there's a runaway inflation, life has become hard, then you double VAT on the cost of petroleum. You impose excise duty on fish. You target milk specially formulated for infants. You impose excise duty, my Lord, on powdered juice, foodstuff. Then that is a regressive tax. My Lord, it's reminiscent of 1 Kings 12:12, where the people tell King Rehoboam that we are suffering, can you lift our burden a little? But he says, I'll double it. That is what happened here. I turn next, my Lord, to
the argument that the National Assembly makes, it says that these are policy issues. Do not go into them, so that you do not interrogate the fairness of the taxes imposed by the Finance Act 2023. The same argument was made in William Musembi. Policy is mentioned 23 times in that judgment, in that case, which I argued. Same issue, dressed as political question doctrine, is made in the CDF case, again, which I argued. The Supreme Court had the CDF case. My Lord, the Finance Act, even if you could not determine issues of policy, the Finance Act is an act. It is not a policy. What you cannot do is decide which policy option the state should make. But once the state makes a policy decision, then it's justiciable. Under Article 10, anyone who formulates a policy or implements a policy, or under Article 165.3, anything done or said to be done under the Constitution. And so, my Lord, that should get rid of that argument. I turn to the climate change issue, my Lord. Now, they increase excise duty on glass bottles and on paper packaging. What is the impact? The impact on increasing excise duty on paper packaging, imported paper packaging, is to pile pressure on our forests, is to make people to resort to unclean options like plastics. That violates or threatens Article 42. And it is irrational, my Lord, considering the Climate Change Act 2016, and that this year Kenya has hosted one international conference on climate change and will, in November, host another on reducing plastic pollution. Yet, this is the year that the National Assembly chooses to impose excise duty on glass bottles, on paper packaging, and to increase VAT on natural gas, a clean energy option. Please find that those climate-leaning amendments violate the right to clean and healthy environment. My Lord, permit me to turn briefly to the money bill question. Now, if you look at Article 109.5, 109 the entirety, a bill can be introduced in any house. But under 109.5, a money bill may be, the word is, introduced only in the National Assembly. The National Assembly, the Attorney General, KRA, take the word introduced and magically transform it to debate. They say that a money bill can only be debated in the National Assembly. My Lord, that would violate Article 96. Because, and the Constitution cannot subvert itself. So you must harmonize. Harmonize 96, harmonize 109.5, and harmonize another article. That is Article 114. Article 114.2 explains why the Constitution demands that a money bill may only be introduced in the National Assembly. And that is because under Article 114.2, National Assembly is given an initial filtering role. One of the few, if not only, situations where the Constitution directly imposes a duty on any committee of Parliament. You will not find it anywhere. Under Article 114.2, the National Assembly must proceed only in accordance with the recommendation of the relevant committee of the Assembly after considering the views of the Cabinet Secretary responsible for finance. That is why 109.5 says you can only introduce a money bill in the National Assembly in accordance with 114. 114.2 says when a money bill comes in, you can only proceed after considering the views of the committee, one, and the committee itself after taking into account the views of the CS for Treasury. My Lord, that reading is constitutionally compliant. It honors the obligation of the Senate to protect counties. It honors the role of the National Assembly to play that initial filtering role, and it respects the value of bicameralism. My Lord, what can affect counties more than their revenue? If, my lord, this is an argument accepted by the Supreme Court. In the CDF case, the Supreme Court was told that look at the objects of this amendment bill. It has nothing to do with counties. It does not mention counties. But the Supreme Court found that the CDF Amendment Act, not the entire act, my lord, the Amendment Act, was a matter concerning county governments because it impacted county revenue. My lord, under Article 102, revenue raised nationally is shared equally among national county governments. So the more the Finance Act raises, the more counties have to share with the national government. The less it raises, the less they have. The Finance Act is a matter concerning county government. And my lord, it's not just about that revenue. The other things they put in there, housing, statutory instruments, including those made by counties. And my lord, I turn next to the statutory instruments issue, repeal, the Statutory Instruments Act, whose Section 21 is repealed by Section 88 of the Finance Act. First, it is not a money bill issue. It shouldn't have been in the Finance Act. My lord, if you look at the list of the statutory instruments, page 56 of our amended petition, you'll find there the Witchcraft Act, Cap 67. What does the Witchcraft Act have to do with finances? Mr. Sore will tell you that because of 114, these are incidental matters. They can go into a money bill. But the Witchcraft Act, my lord, how is it incidental?
Probably the chiefs will have just one.
Yes, my lord. My lord, the Subordinate Courts Separation and Maintenance Act, my lord, I beg my colleagues to just allow me 3 minutes to finalize. The Subordinate Courts Separation and Maintenance Act, Cap 153. What does that have to do with taxes, with levies? It is not a money bill issue. The Telegraphic Press Messages Act, Cap 512, which you find at page 62 of our amended petition. My lord, I wonder when the last time my lord heard of a telegraphic message. In short, they put non-money bill issues into the money bill, the Finance Act, and this is why they did that. In May this year, Annexure CN 1, 2, and 3, you'll find a resolution and answer debates by the Senate refusing to extend the life of some 1,700 statutory instruments whose term had expired under Section 21 of the Statutory Instruments Act. My lord, that staged automatic expiry has a constitutional value. If you look at Article 96(4) of the Constitution, delegated legislative power is limited. It's limited because Parliament itself is exercising a delegated power. And so when it gives it to the Cabinet Secretary, it must retain some control. And so the power to make delegated legislation is controlled. Section 4 of that Act, the Statutory Instruments Act, requires mechanisms, my lord, to ensure the ongoing review of statutory instruments to ensure their continued relevance. Regulations made under the Witchcraft Act, my lord, still bind the Kenyan people. You'll find regulations made under repealed acts. The law is that if you repeal a statute, the regulations continue unless separately repealed. And so, my lord, the purpose of Section 21 was to ensure the ongoing usefulness of statutory instruments. The National Assembly knows this. Look at CN 5, which is the report of the National Assembly, at page 552. It's the National Assembly, I quote, notes the importance of constantly reviewing the statute book. The Senate also knows that. You'll find that at CN Roman numeral 1 at page 51 of our amended petition, the Senate says it's important to scrutinize the statutory instruments to ensure their relevance, justification, and rationale to extend their life. And my Lord, they can only extend for 1 year, 12 months. And so the purpose and effect of repealing Section 21, my Lord, was to defeat that Senate resolution. And you'll hear the Senate Speaker telling you that they had agreed with the National Assembly Speaker that this bill did not concern the Senate, despite this amendment. And so, my Lord, find that one unconstitutional. Look at the Queensland Statutory Instruments Act 1992. It explains also the rationale for staged expiry in a manner that concurs with what the National Assembly and the Senate say. My Lord, allow me to conclude with the issue of meaningful public participation. My Lord, you decided the CIC case. Justice Odunga decides Robert Gakuru. There are other decisions. And my Lord, we are not saying that every view presented must be adopted. No, that is not the claim here. We are saying that every view presented must be considered. That is the law. My Lord, that is the law in BAT Supreme Court. That is the law in the GIFT principles, the global initiative for financial transparency, which Kenya has signed up to. It's also the law in the OECD principles, clarity of subject matter, my Lord, complementarity. The view presented must be shown, must be considered, and the state organ must demonstrate how they took into account that view or why they rejected it. My Lord, look at page 398 and 399 of CN5. You'll find this remark. The committee rejected the proposal by LSK, full stop. Rejected why? Was there a better view? Was LSK disliked? Rejected why? My Lord, page 467, Okoa Uchumi, the people I represent, the committee rejected the proposal, full stop. Rejected why? What is the reason for rejecting? Trade Union Congress is a petitioner here. Page 469, the committee rejected the proposal, full stop. My Lord, the report does not show that every submission given was considered. My Lord, there's worse. The KRA at paragraph 44 tells you, 44, that the National Assembly considered all views given, but 44 times, CNX 5, the CFA and Twaweza counted and found 44 submissions left blank, without a reasoning, without indication of what happened to that, 44 times. And my Lord, about 80 submissions cannot be accounted for. What happened to them is not known. And so, my Lord, we submit that there was no meaningful opportunity for balanced influence on the decision. The last one, Okoa Uchumi, page 316 to 361, makes 57 submissions, nearly 60. Only 4 are recorded. Of those 4, 2 are marked as the committee rejected the submissions. My Lord, there was no meaningful influence, meaningful opportunity for public influence. Thank you so much, and I apologize to my colleagues for exceeding the time.
Ogada. Evans Ogada for the 6th and 7th petitioners. Your Lordship, your Ladyship, I pick up from where Senior Counsel Otiende Amolo left, and he equated this court to the bastion and bulwark of constitutionalism in this country. Quickly, in terms of comparative constitutional law, the year is 1919, August 11th specifically, whereby the Weimar Republic ushers a new constitution after the fall of Germany. That constitution is important for this reason. It had a Bill of Rights, and it properly recognized the individual as the locus of authority, just like our Constitution 2010. That Constitution had a shelf life of 3 years. It failed. Why did that Constitution fail? For these reasons. One, it was deliberately undermined by legislation under it. Two, it was deliberately undermined by political action. Your Ladyship, Your Lordship, you are the bulwark, the bastion of constitutionalism. And we have submitted to you our authority number 1, page 1 to 72 of our bundle of authorities, that legality, the principle of legality, is one of the tools that the judiciary uses to examine the acts of state. Your Lordship, Justice Mugambi, you asked a question on public participation. It has been flogged enough, but I want to give precise bullet point answers. Public participation is a principle enacted to address limitations of representative government. Therefore, if I had time, I will take us to the history of democracy in its incipient stage, whereby we used to sit as Africans around tables and make decisions through consensus. There's a tool called the Boule, B-O-U-L-E. The Greeks had the Agora, whereby decisions were made from a small platform. That is what public participation intends to do, to take us to that environment where decisions were given meaning and at least accounted for. Secondly, Your Lordship, legislators do not always represent the views of the people. In theory, they are supposed to. In fact, they do not. Our first-past-the-post electoral system has ensured that certain ethnic minorities are excluded by the majoritarian interests, and therefore they are dominated, excluded from governance. That is why public participation and the need to account for the views given is important. The mechanisms that facilitate effective public participation ensure that these people are respected. They are included in the democratic cog. I will not belabor public participation further. There is the BAT case that issued guidelines. I had a position here that Parliament is considering legislation on public participation. I take a different view. Once the Supreme Court has synthesized and distilled the elements of public participation, given as constitutional law, qua Article 94 of the Constitution, that is law. Parliament has no business legislating on it. So the guiding light for this court, in terms of what amounts to public participation, we go to the BAT case by the Supreme Court. And the Supreme Court, echoing what George Vincent Odunga J in Ex parte Gekuru, those two decisions give a conjunctive test. There's a qualitative and quantitative element to public participation. Those elements have not been met. I move next to the impugned notice by the Cabinet Secretary in charge of housing, ostensibly in exercise of powers under Section 84, read together with Section 31 of the Employment Act. Error. Under the law, Section 2 of the Employment Act, as read with Section 91 of the Employment Act, the authority to make rules and any instrument worth calling itself a statutory instrument under the Employment Act is within the domain of the Cabinet Secretary in charge of labor matters. Not the CS, housing and transport. I can almost bet my dime that I will be told there is the principle of collective responsibility, and therefore any CS can do what was done in those impugned notices. Those of us who studied law at second year remember the principle of delegatus non delegare potest. A delegate cannot delegate any further. So when you are a CS and statute delegates to you authority to make rules, that has to be read with the interconnectedness with Article 94. And therefore, when Parliament, through the Employment Act, specifically Cabinet Secretary cannot delegate it any further. My brother Ochiel has submitted, and others have submitted, on the Statutory Instruments Act. That act has to be read together with the provisions of the Interpretation and General Provisions Act. The following provisions complement the provisions of the Statutory Instruments Act. Your Lordships, Your Ladyships, Section 27 of that Act. All subsidiary legislation have to be published in the Gazette and shall come into operation on the day of publication. Important. The question is, this notice appointing KRA as an agent, in addition to the shortfalls identified with the Statutory Instruments Act, impugns Section 27. Retrospective application, Section 28 of that Act answers us. I will invite the court to look at it. Section 33 of this Act. Acts done under subsidiary legislation are deemed to be done under the Act which authorizes it. Again, buttressing our argument, Section 2, Section 91 of the Employment Act. The Cabinet Secretary, who ought to have issued guidelines, who ought to have appointed KRA, if at all, was the Cabinet Secretary in charge of employment matters, not labor. Employment and labor matters, not housing. Section 34 requires that any instrument in the nature of rules and regulations has to be laid before the National Assembly. The notice, the impugned notice and the agency notice to KRA holds out in its Austinian sense. John Austin. We were forced to obey the command and we remit taxes or levy, whatever it's called, ostensibly because of those rules. Your Lordship, those rules ought to have been submitted to the National Assembly by virtue of Section 34 of this Act. In conclusion, and as I wind up, a lot has been said about policy, that this court ought to keep off political questions. The lead decision of Justice Joel Ngugi in the BBI case, David D. and others, ably captures the authority of this court as captured in Article 165, such that merely a threat to the Constitution is an invitation for this court to deal with that threat whenever it occurs. The Constitution 2010 baptizes this court as a Kelsenian court. This is a court that is supposed to do judicial review. And judicial review, under the context of the Constitution 2010, and reading specifically the principal provisions, Article 10, the Constitution 2010 mandates this court to even examine policy considerations, however crafted. Anything that lacks legitimacy cannot be effective. Lacking in effectiveness, they cannot develop legitimacy. Those are not my words, those are the words of Samuel Huntington, third wave of democratization in the late 20th century, attacks in political science. Basically, anything that was not procedurally proper, constitutionally infirm, cannot be a material of governance. Anything done without according to the authority of the people as the sovereign locus under the Constitution 2010 cannot be baptized, cannot be solemnized by an imprimatur of this court. We humbly submit. Thank you.
my lady, and my lords. My name is Robert Kamwara. For the record, I will be relying on my amended petition dated the 9th of August 2023, my affidavit sworn on the 9th of August 2023, my further affidavit sworn on the 24th of August 2023, my written submissions dated 24th, and my supplementary written submissions dated the 8th of September in response to the first and second respondents' submission. And my first stones, my lord, one of them is openness, opaqueness, accountability, and ambiguity. I want to put section 84 on the weighing scale. And my lord, the purpose of doing this is to demonstrate how section 84 is ambiguous. In this case, I will be asking a question: is section 84 of the Finance Act unconstitutional? And the answer to the affirmative. This section has been enacted to ensure that there is as much opaqueness as there can be. Why do I say that? When the Finance Bill was brought to the public for the public participation, the Finance Bill in itself stipulated clearly the issues that through the Employment Act would be amended, and the benefits that the members of public, those who are employees and employers, would benefit from. I'll read in brief. In the small titles that are the marginal titles, one of the things that was supposed to be amended was that there would be a national housing fund, a national housing development fund. My lord and my lady, on the enactment of the Finance Act, nothing like this was demonstrated. Further to that, the Finance Bill was clear, and it had stated that employees were to qualify for affordable housing. And who are these? It clearly stated, and it is said that employees would benefit and they would be financed for purchase of a house. The Finance Act that came out, my lord and my lady, did not have that. The Finance Bill further was clear on how funds would be transferred back in the event that somebody retired and did not need to use the monies that he had paid from his employment. The Finance Act does not address that. It's clear that the space between the Finance Bill up to the time of the enactment of the law, there was a lot of ambiguity that took place. No openness came out, and we can comfortably say that the Act is purely ambiguous. It is meant to confuse. Initially, it was very clear, but later was meant to confuse Kenyans. Article 10 and Article 201 on principles of public finance, the Public Finance Act clearly states that everything should be open and there should be no opaqueness in anything. There was no transparency, bearing in mind that the Constitution has only provided for 4 kinds of taxes. That is the income tax, VAT, excise, and customs. We are blind to where this housing, affordable housing levy, should be allocated. Fine. The legislators are saying, or the respondents are clearly saying, that there is Article 209(2) that allows the creation of additional taxes. The legislators can put in new taxes. But in this case, where can we present the housing levy to? It is not clear. The first respondent, in his replying affidavit in paragraph 24 and 25, alleged that the funds were to be governed by the National Housing Corporation. However, the Act is silent. The Act does not say where the money is going to be taken to. These are a lot of funds. The month of August itself, a lot of monies were deducted from all these people who are seated here and those also in the bench. Monies were deducted from their salaries, but truly the money cannot be accounted for. I wish to now bring to your attention my second point about opaqueness once again. And Section 84 states that the levy shall be deducted from the gross pay of employees. What is gross pay? What is gross pay? The fourth respondent has attempted through an instrument which I would call a public declaration or a roadside declaration that gross pay is 1, 2, 3, 4 things. There is nowhere in the Income Tax Act that this has been properly defined. There is nowhere gross pay has been defined. In that case, the public finance management legislation states that there should be clarity, and the purpose is to collect as much as possible. We can tell the reason why the Finance Act put in the affordable housing is purely just to collect money, monies that cannot be accounted for. Therefore, we can say no accountability, despite the fact that we want to collect as much using the ambiguous methods of collecting cash. I'll rely on my bundle of documents on paragraph 24, Republic versus Commissioner of Domestic Taxes. And my Lord, on this, I'll rely on the Bidco Oil Refineries versus Attorney General. In the judgment, it was clear that it is within the authority of the legislature to enact legislation governing the manner in which particular form of taxes is to be administered, including the manner in which it is to be imposed. Therefore, the legislation or the legislature did not cover or did not undertake its work to fully ensure that Article 210, to ensure that the taxes that were being created were properly collected. Article 201 and Article 10 then can clearly be seen to be infringed, because in Article 10, accountability, national values, good governance on how the funds are going to be utilized does not seem to be coming out. Further, I wish to demonstrate that in Section 84, there was a lot of ambiguity because the fifth respondent purported to appoint the fourth respondent. However, it should be the vice versa, where we have the CS, Treasury, who should be appointing Kenya Revenue Authority, and not the CS of lands appointing Kenya Revenue Authority to do the collection of tax. Under what law was the appointment done? It is clear that there is ambiguity and that there was no clarity on those issues, and therefore the reason why they had to quickly try and circumvent and get the Commissioner of Income Tax putting up something very fast to collect the funds. The first and second respondent justifies the appointment of the fourth respondent on basis of Section 75 of the PFM Act. But my lords and my ladies, this is not right. Only the CS of Finance can appoint the fourth respondent to undertake collection of revenue, and in that way then, this was a true intervention, a true contravention of the law. This was actually intentional, I would say, to create more opaqueness on the violation of Article 10, violation of Article 201, funds taken away from members of public from hard-earned money, being diverted into accounts that cannot be explained, rightly denying the right of property to members of public, and defying and infringing Article 40 of the Constitution. It's actually unconstitutional and pointing to the fact that there is a lot of opaqueness on this issue. The Statutory Instrument Act also clearly... Thank you, my lord. Sorry for that. The Statutory Instruments Act in Section 5 breathes life into Article 201 of the Constitution, where we say that public participation should be actually undertaken when you want to enact any document, like the guidelines for KRA. This was not undertaken. So, my Lord, I wish to submit that the Section 84 of the Finance Act be declared unconstitutional, and therefore we pray that the petition be prayed as allowed, and I wish to thank you, my Lord.
May it please my lord, my lady, my name is Ongoya. I appear for the petitioners in petition number 234 of 2023. In summary, my lord, my lady, the petitioners rely on the amended petition dated 10th August 2023 and the supporting affidavit of Dr. Charles Muhwaya of the same day, as well as the written submissions and the list and bundle of authorities, all dated 5th September 2023. In the interest of time, I adopt the averments in the petition, the depositions in the affidavit, and the contents of the written submissions, and wish to highlight the following brief aspects. Number one, this petition brings on board the voice of the workers in this dispute. If the Finance Act 2023 shall go down in history as an oppressive piece of legislation to the Kenyan public, then the most oppressed, the core of the oppressed in that statute shall be the workers of this country, as I will demonstrate shortly. There are two aspects that these petitioners focus on in their challenge of this legislation, and that is number one, that part of the Finance Act, that is Section 26, that amended the Income Tax Act to increase certain individual income taxes. And number two, Section 84 of that Act, which amended the Employment Act at Section 31B, so by introducing Section 31B. Allow me, my lords and my lady, to begin by laying the constitutional basis of this challenge. I will start with Article 19, Clause 3B of the Constitution, which provides that the rights and fundamental freedoms in the Bill of Rights do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law, except to the extent that they are inconsistent with this chapter. Then clause paragraph C, which provides that those rights and fundamental freedoms are subject only to the limitations contemplated in this Constitution. It follows, therefore, that the rights of workers that are provided for in, among other statutes, the Employment Act, form an integral part of the Bill of Rights by instrument of Article 19, Clause 3, Paragraph B of the Constitution. And therefore, if one wants to limit the rights of workers as set out in the Employment Act, they must comply with the criteria for limitation that is spelled out in Article 24 of the Constitution. And this is what then Parliament does in enacting Section 84 of the Finance Act. It amends the Employment Act by inserting Section 31B, which provides that notwithstanding the provisions of Section 3(2)(a), B, C, and D of the Act. This is a very egregious part of this statute, because this is what the statute does. Section 3(2)(a), B, C, and D of the Employment Act removes certain persons from the application of the Employment Act. It says if people employed under the Armed Forces Act, under the Prison Service Act, and the National Police Service Act, and that act, the Employment Act, does not apply to them. What Parliament does in the Finance Act is to bring them back to the Employment Act for the limited purpose of taxing them. It says we shall bring it, notwithstanding sections 3(2)(a), B, we shall bring you back for the limited purpose of levying the housing levy on you. Then disapply the rest of the provisions of that act in terms of the other rights of employees to you. It's the only statute I know, my lord, that imposes only obligations on a subject and expressly denies them corresponding rights under the same law. That is the Finance Act that is being litigated before you today. But in the interest of time, what is the net effect of these two provisions that we have singled out? The Trade Unions Congress appeared before Parliament and has come before you and said, look, there is Section 19 of the Employment Act that ring fences, that protects wages and incomes of employees from unregulated deductions. All of them, including statutory deductions like taxes. And it says, okay, we are going to allow the following categories of deductions. But says, whatever you do as the deducting agency, the employer, if you may, do not effect deductions on the salaries of an employee so as to leave an employee with anything less than 1/3 of his income. So the Trade Unions Congress goes before Parliament and says, look, if you wantonly introduce new taxes targeting employees, as you have done in Section 26, increase the Income Tax Act for certain bands of employees, and through introduction of Section 31B of the Employment Act, introduce a new tax, the housing levy, what you do is that you are adding them to the existing deductions, and the employer has no choice over these ones. Address yourselves to that question. Apply your mind to it, that what is the effect of these consequential amendments to the protections under Section 19 of the Employment Act. My learned colleague Ochel Dudley summarized for you what the Parliament said. It said that invitation is rejected. Why? Are you saying that it's nonsensical? It makes no sense completely. Are you saying that when stakeholders tell you that apply your mind Section 19 of the Employment Act, they are being irrelevant in the considerations that they are inviting you to apply? It's that kind of arbitrariness where an invitation of this nature is rejected by a wave of the hand with no reasons supplied that delve a debilitating blow on the constitutionality of these provisions of the Finance Act. They render provisions on public participation illusory. They have no effect. My clients at least expected reasons on why these invitations take into account the provisions of Section 19 of the Employment Act were not taken on board. But more importantly, when we bring the matter before this court, what do the respondents tell this court in their replies? They say no. The duty to ensure Section 19 is complied with is not that of we the lawmakers. That's in complete violation of Articles 20 and 21 of the Constitution that make it the obligation of every person to ensure respect for rights and freedoms. So it says not the obligation. It is the obligation of the employer. And two, it is for the employees, that's what they are saying in their responses before you, to go and negotiate with the other lenders, the people they owe the Shylocks, to rearrange their deductions so that they remain within that minimum 30% rule. It is not the obligation of Parliament to take that into account. I submit respectfully that the state's obligations to protect its citizens was highly compromised by that attitude on the part of the lawmaker as they made this law, and on their part as they responded to the petition before this court. Allow me to also address the impact of Article 24, Clause 2A of the Constitution on the matters before you. Article 24, Clause 2, Paragraph A, provides that despite Clause 1, that is the clause on how rights can be limited, a provision in legislation limiting a right or fundamental freedom in the case of a provision enacted or amended on or after the effective date, as is the case with the Finance Act here, is not valid, that's what I'm emphasizing, unless the legislation specifically expresses the intention to limit that right or fundamental freedom and the nature and the extent of that limitation. We submit that an employee has proprietary interest in his income. An employee's income is an employee's property, duly acquired after laboring for the period of labor for which he is paid. For the lawmaker to enact provisions in the nature of Section 26 of the Finance Act and Section 84 to take away a part of that property, by law, compliance must be had to Article 24, Clause 2, Paragraph A of the Constitution. We invite you to look at that law, and you will realize that in terms of the bill, the proposal to enact that law in the nature of the bill, it lacked that specificity in terms of specifying that it intended to limit employees' property rights within the meaning of Article 40 of the Constitution. And what the Constitution says is that if that happens, then that legislation is not valid. It's against this background that the petitioners in petition number A234 invite you to declare that sections 26 and 84 of the Finance Act are invalid and of no effect, and to strike them out accordingly. In addition to all that, I invite you, my lords, to look at our written submissions that explain those points in detail, and we rest our submissions at that juncture. Thank you so much for the audience.
E237 of 2023. This is the petition by Frederick Onyango Gola and others.
Thank you very much, Your Lord and Lady. My name is Professor Fred Ogola, first petitioner in the petition E237 of 2023. I'm not a lawyer, but I'm a governance expert, so that's the angle we're going to take. I place my reliance on the petition that we have filed, our written submissions, and the accompanying list and bundle of case digest. I seek to answer 4 questions for my submissions today. And the questions I'm going to give for the submission today is whether the imposition of VAT on insurance compensation is unconstitutional. The second question is whether the Finance Act and all certain provisions in the Finance Act are unconstitutional. The third question is whether there was sufficient public participation in the process leading to the enactment of the Finance Act. And the last question I want to raise, Your Honor, is what are the roles and duties insofar as the petition that is before you is concerned. So to start with, VAT on insurance compensation. Instances where VAT may be imposed are as follows. With regards to imposition of VAT on insurance compensation, in answering the question whether insurance compensation is legible or not, VAT must be subjected as insurance compensation is not a consumable if you like, service or good, and therefore they should not be taxable as they are being subjected to the current tax with the Finance Act. So to the extent that you find that it is inevitable to find that insurance compensation is not a consumable good or service supplied, you must therefore reach out an inevitable conclusion that the imposition of the VAT on insurance compensation in the Finance Act is in violation of the Constitution of Kenya 2010. The second question is on the unconstitutionality of the various sections of the entire Finance Act. In addressing you on this issue, my lady and lord, I submit that your duty and obligation under this issue is, so far as the case of the petitioner is concerned, is to interpret the Constitution and apply the Bill of Rights. In applying the Bill of Rights, you are mandated and obligated to adopt an interpretation that most favors the enforcement of a right or fundamental freedom contained in the Bill of Rights as directed in Article 23, Clause B. You are also additionally required to utilize and apply the constitutional principles on interpretation of the Constitution under Article 259, which requires you to interpret the Constitution in a liberal and purpose approach in a manner that protects and promotes the purpose and principles of the Constitution. Your Honor, I'm not just a consequentialist where consequences determines what people should do, because that is a happy path. But more specifically, we have to say that we submit that we have to look at the two parts where we talk about both purpose and the effect of any legislation, because sometimes the effect can be good, but the purpose is lost. What then was the purpose of the Finance Act? By its name, it's an act that helps the government raise finances to cater for its budgetary expenses for financial year 2023-2024. The petitioners, in the petition before you, is agreed by the effect of the said act on the Constitution, which I now proceed to address you as follows. 1, all of us in this room might know that it's been stated that this Finance Act was the most popular act in the history of Kenya. Without evidence, I don't want to go there, but all we know is that it was least intellectually debated. As my colleague said, reject, reject, reject. There was no intellectual discourse. So on the public participation, on the face of the petition that is before you, we have shown and demonstrated that the certain sections of the Finance Act were amended when the act was still a bill before the floor of the House of the third respondent, that's the National Assembly. Honorable members of the court, public participation is a constitutional requirement under Article 10, Section 2 of the Constitution. Consequently, I invite you to find that the extent that the impunch clauses, which we have stated, were introduced to the bill and not subjected back to public participation, in their express view, the said sections are violative of the constitutional principle of public participation, which serves the purpose of informing the public of what is expected and to their concerns and fears. The second one, on discriminatory nature of the housing levy in contravention of Article 27 and 43 of the Constitution of Kenya 2010. My lords and ladies, the housing levy as passed under the Finance Act requires mandatory contributions from both the employer and employee. It means therefore the right to housing provided for under Article 43, Section 1 of the Constitution of Kenya 2010. The effect of this is that only the persons who are employed will have the benefit of being able to have the right under Article 43, Section 1 of the Constitution enforced. Only persons who are employment, thus violation of constitutional rights, principle of non-discrimination on the grounds which is contrary to Article 27, Section 4 of the Constitution. My lords and ladies, as I finish my submissions, which of course you see is precise, I would like to urge you not to bury your head from the issues affecting Kenyans, like the Court of Appeal did at the Supreme Court already. Just do the right thing. Don't be scared of the injustice already done by the higher courts, because we believe that from the low courts you can get justice, and sometimes justice appears as you go the sky above. And I would like to plead to you that you might be able to consider the plights of Kenyans who are suffering in these taxes as being listed here in many ways, and the inconsistencies in it that we make before you. With those few remarks, I urge you to allow the prayers sought in the petition number E237 of 2023 as prayed. I thank you, my lady and lords, for listening. Thank you.
Thank you very much. There was a Mr. Jerry Owor in the same matter.
Yes, he was in the same petition.
Okay, since he's not here, we move on to the next. E254 of 2023, Mr. Arwa. And Mr. Arwa, you're eating into the time of the interested parties.
My lords and my lady, in that matter, as I indicated earlier, I appear together with my colleague, Ms. Adunga, for all the petitioners. Unlike all the other petitions, this particular petition challenges only one provision of the Finance Act, specifically Section 47, Paragraph A, Subparagraph Roman 12.
Section?
47A, Roman 12. My lords and my lady, the position of the petitioners is that this particular provision is unconstitutional and should be declared as much. The main reason why the petitioners contend that it is unconstitutional is because it was never contained in the bill that was published on 28th of April 2023 and which was submitted to public participation. My lords and my lady, there are several other issues that we intend to raise, most of which have already been touched on, and therefore I will not dwell on them. I'll only touch on the aspects of our submissions that have not been submitted on by my other colleagues. And specifically, my lords and my lady, I will be addressing basically 6 issues. Number 1, how do constitutional values implicate the legislative process? Number 2, what amounts to a bill for purposes of Article 109 of the Constitution? Number 3, what does public participation in legislative process entail? Number 4, what does amendment of a bill actually entail? 5, what is the implication of the impugned section on the right to health? And finally, what is the implication of that particular legislative provision on socioeconomic rights entrenched in Article 43 of the Constitution? So I will start with the first issue. The implications of constitutional values on legislative process. And my lords and my ladies, I submit that this is not an idle point. I will start with Article 10, Subarticle 1, Paragraph B. And this is what it says. National values and principles of governance in this article bind all state organs, state officers, public officers, and all persons whenever any of them, in paragraph B, enacts or interpret the Constitution, any law or the Constitution. My lords and my lady, the substance of my submission is that these constitutional values bind Parliament. And every step they take in the legislative process must take into account these values. Specifically in relation to Section 47 that we are complaining about, it is admitted by all respondents that it never featured in the bill. And if you read paragraph 10 of the affidavit sworn by Samuel Njoroge on behalf of Parliament, he clarifies, my lords and my lady, that when the bill was at the committee stage, some proposal was presented to the committee. And it is this proposal that was eventually passed into law. Essentially admitting, my lords and my lady, that this proposal was introduced on the floor at the committee, at the third reading stage, sorry. And that, my lords and my lady, you will see in paragraph 10 of the affidavit sworn by the Speaker of the National Assembly. So the question, therefore, is whether a bill, a proposal which is introduced at that late stage can be enacted into law without being taken back for public participation. And our submissions, my lords and my lady, is that it is not possible. And it's important to note, my lords and my ladies, that Parliament was very much aware of that. I invite my lords and my lady to look at pages 80, 81, and 86 of the report that was presented by Parliament and annexed to the affidavit of Samuel Njoroge. In those 3 pages, you will see that Parliament actually rejected other proposals that were introduced for the first time at that stage. Meaning that they were, and the reasons given was, these matters have not been taken for public participation. So what we see here, my lords and my ladies, is a situation where Parliament selects which new proposals to enact into law and which new proposals to reject for failure to comply with public participation. And it is our humble submissions, my lord and my ladies, my lords and my lady, that Parliament cannot do that under our constitutional dispensation. Specifically, Article 10 entrenches the value of integrity, the value of transparency, the value of equality, and the value of good governance. All these values bind Parliament. The value of integrity cannot permit Parliament to choose which new legislative proposals to accept and which new legislative proposals to reject. They must act with integrity. And this is a constitutional imperative. Secondly, my lords and my lady, the value of transparency require Parliament to explain to Kenyans on what basis they reject some new proposals and on what basis they accept other new proposals. It is a duty which they have to explain to Kenyans why some new proposals are being accepted and others are being rejected. Otherwise, we are going to encourage impunity and arbitrariness in our constitutional dispensation. Thirdly, my lords and my lady, Parliament owes a duty to all Kenyans who submit proposals for their consideration. And where two Kenyans submit new proposals at that late stage, it is not fair for Parliament to choose to treat one of them differently from the other. So all the stakeholders who submitted new proposals at that late stage were entitled to be treated equally. And it is not for Parliament to decide which one to be given favorable treatment and which one to be rejected. And finally, my lords and my lady, our submission is that Parliament, after all, does not have the power to selectively choose what to accept and what not to accept when they are all submitted at a very late stage. Those constitutional values bind Parliament, and where Parliament acted in clear violation of such values, then whatever it does amounts to a nullity. Well, the second issue is what is a bill for purposes of Article 1. My Lord, allow me just to wind up. My submission on this front is that every legislative proposal must be contained in a bill. And that means that it is what is already contained in a published bill that can be submitted for public participation. It is therefore inconceivable that a new proposal can feature for the first time in an act of Parliament, my Lord. Section 47A that we are complaining about will not be seen in any of the versions of the bill. And you have them before you, my Lord. It features only for the first time in the Act, meaning that this is a proposal that never appeared in a bill and could not have been passed within the meaning of Article 109. As concerns the issue of public participation, my Lord, I just wish to point out that this is an issue that has been considered before, and the courts have held that where a new proposal is introduced at a very late stage, then that proposal must be taken back to public participation. And that is what ought to have happened in this case. My Lord, there is the question of what amounts to an amendment. An amendment, in our humble submission, must mean and mean only an amendment to an existing proposal in the bill. Cannot mean introduction of a new bill, a new provision that has never featured at all in the bill. My lords and my lady, therefore, it was not possible for this particular provision to have been introduced by way of amendment. And that is the same with other provisions, my lord, that my colleague Mr. Molo had referred to, all the 25 of them. Finally, my lord, allow me to point out that these proposals have got adverse effect on the right to health and socioeconomic rights, to the extent that they will increase the cost of medicine and place the medicines beyond the reach of ordinary mwananchi, thereby violating their right to health, which is entrenched in Article 43. It is also going to make it very difficult for our pharmaceutical manufacturers to compete favorably with other global manufacturers. Now, on this point, my lord, we are aware that Parliament can pass legislations that limit fundamental rights. but they must meet the requirements of Article 24. And our submission is that that consideration never featured at all. My lords and my lady, for those reasons, we humbly urge this honorable court to allow our petition and grant the order sought. Thank you.
There was and you have now I'm guillotine. We are on guillotine mode. We only have half an hour and Mr. Mtata must be heard. Yes. Mr.
My name is Leslie. I appear for the petition in 211. The petitioner is one Mr. Peter Odiambagor.
You have 5 minutes.
My Lord, we bring our submissions in support of the petitioner's petition, which was dated on 23rd June 2023 and late amended on the 29th June 2023. The petitioner's petition was to the effect that the Finance Act was not subjected to public participation, and the outcome thereto, when the public were interviewed, the outcome thereto was not considered, because basically it was rejected on a greater percentage, and for sections that got assent of some members of the public are not the same that were eventually passed into the law. The petitioner relies on Articles 1, Article 2, Article 10, 19, 22, 23, 159, 162, and of the Constitution, and they invokes all the constitutional provisions which are stated. The prayers sought in the petition are that the Act be declared to have been unprocedurally introduced, and it is unconstitutional and null and void. The further requires that the first respondent be compelled to amend the Finance Act, to put it back to the public and have it amended to go in tandem with the Constitution of Kenya. That another prayer is that it is the Act is in violation of the Constitution of Kenya, especially Articles 10 and 47 of the Constitution of Kenya. There is the introduction of the 16% of fuel prices, which was introduced by April, such be declared null and void, and the same be suspended. The petitioner has pointed out these specific provisions that as to Section 52 specifically of the Constitution Act violates the rights to property which are spelled in Article 40 of the Constitution. Article 40 of the Constitution, my lord and my ladies, provides that the property is protected and jealously so protected, but the Act goes against such protections, breaks through to collect revenue from what was not actually introduced to anybody, to the public, and the public did not actually assent to the same. We have a question which we shall require that our petition answers is whether the respondents failed in their duty on the rule of law and protection of the Constitution. As provided, the respondents failed to protect the Constitution. They went against the rule of law, and it is a danger to the society which is protected under the Constitution. My lord, we have provided statutory provisions under which we have brought the petition, as well as cases which have previously been determined, and finding being that what was taken through what has come out as a Finance Act is actually something that is pardoning the public rather than assisting the public in it. Is the cases which we have cited include Concurrence versus Virginia, number 19 of USA 264, which provides that court will take jurisdiction if it should, but it is equally true that it must take jurisdiction so as to enable the legislature provide good laws. Finally, my lord, because we have submitted this one in written, we pray that the specific sections of the law provided in the Finance Act be declared null and void, and or have the whole document declared as a nullity and be nullified by this honorable court.
Thank you.
Thank you.
We now deal with the practice. Kenya Revenue Authority, do you support or oppose the petition?
We oppose the petition and we are responding in all the way.
Okay, so you wait for your turn. Senate, Mr. Cecil Miller, oppose or support the petition?
We oppose, my lord.
So you wait for your turn. Consumer Federation of Kenya, they are not here. Kenya Export, Floriculture, Horticulture and Allied Workers Union, you oppose. You are with Mr. Ongoya. We will take that into account. Devki Steel, Mr. Kate, you oppose or support? You oppose. And Electric Mobility Association of Kenya? You oppose. And Kenya Airline Pilots Association? You support the petition, and you have all filed written submissions. Thank you. Mr. Omtata, where is he? You were supposed to be prosecuting somebody.
Yes, I thought you could finish with the petitioners and those supporting the petition.
They have finished with them. They are interested parties. You know, they are like passengers in a bus. They either support or oppose. They have no independent right of existence. Yeah. But we will consider them. So, Mr. Umtata, you have 15 minutes to make your case, and then we break for lunch. And where is the alleged contemner? He should be standing somewhere with police so that he doesn't run away. Come and stand here so that we all see you and so that you can hear the accusations being leveled against you. Are you represented?
Yes, I am. Good afternoon.
Yes.
Mr. Hassan Nura.
With me?
My name is Isa.
Yes. Okay. And you are ready to proceed?
I'm ready to proceed.
You filed all your documents?
Yes, I filed my response.
Okay.
My list of references.
Okay. So sit down. Mr. Umtata, make your case.
My lords and my lady, I just checked with my time. I think I have 24 minutes that were allocated to the...
Because as I told you when we started, we thought we were young, negative old. We have actually sat here without a break.
I'm guided, my lord.
Yes.
Yes, my lord. The application is dated the 4th day of July 2023. And it seeks 3 prayers. Prayer A is that the Honorable Court be pleased to cite Mr. Daniel Kipto Bargoria, the Managing Director of the Energy and Petroleum Regulatory Authority, for contempt of valid orders of this court issued on 30th June 2023, which were duly and effectively served on him electronically on the same date and physically on 3rd July 2023, and consequently commit him to jail for such a period not exceeding 6 months or such a period of time as this honorable court may deem fit, and or proper as would be sufficient to punish the contemner. The other prayer seems to have been overtaken by the way the court directed proceedings, so that it requested that the first and second and third respondents be denied audience until the contempt is purged. I also prayed that the costs be granted in this petition. I've laid out the grounds of the contempt. It's not in doubt that the High Court issued orders suspending the finance bill, the Finance Act, initially ex parte and later inter partes. After the issuance of those orders, which were very, very widely canvassed in social, in media, both the press and social media, the electronic media, the contemnor proceeded to implement the suspended act by issuing an advisory, raising the prices of petroleum products as contained in the Finance Act 2023, which had been suspended. It was within his knowledge that the act had been suspended. The order was served on him. I even took the extra step of looking for his mobile phone contact, which I got, and we engaged in a lengthy discussion, which I've attached as evidence on this application. I've also attached a certificate to comply with the Evidence Act of the equipment I used. We also have an affidavit of service confirming service of the orders on the organization which the Contempt heads. All these efforts, Your Lordship, amounted to nothing. For him, the court had no authority to suspend the act, and he was not going to abide by the orders of the court. So, my Lord, this court has inherent jurisdiction to punish for contempt of its orders, even in the circumstances whereby the Contempt of Court Act was voided by this court. It still contains that power, and the authority of the courts, my Lord, is something that cannot be negotiated or ignored, because as the custodians of the Constitution, if somebody ignores a court order, then it's basically overthrowing the Constitution. So, my Lord, with those few remarks, I pray that Mr. Daniel Kipto Bargoria, who issued the advisory implementing the Finance Act, when the orders issued by this court were still pending, were in force, and had not been suspended as they were later suspended by the Court of Appeal, should be punished according to the law of the land, and also should be used to set an example to others who would be equally minded to think that because they occupy certain offices, they operate above the law. With those few submissions, my Lord, I'll pray on my motion. I'll rely on my motion, hold the contempt in contempt of this honorable court. Thank you.
Thank you very much. We now come to our break. We'll break and come back at 2:15. 2:15. We'll continue now with the rest of this case. Agree amongst yourselves how we will respond together with the interested parties. You are part of the Senate, you're not separate. There is only one Senate.
So, arrange yourselves and we'll come and finish. Thank you very much. Let's break.
One Senate, one National Assembly, National Assembly.